Hello and welcome to the Employment Law Centre of Western Australia. In this video we will talk about what you might be able to do if you lose your job, whether it's because you have been dismissed, because you feel you have been forced to resign, or because you've been made redundant. Employment law can be complex and there are often exceptions to the rules. On top of that, the laws often change, so please remember that the information in this video is a general guide only. It is not legal advice and the information is for Western Australian employees only. If you want legal advice about your specific employment law issue, please call our telephone advice line or contact a lawyer. All employees have workplace rights. If your employer decides to make your role redundant, or if you are fired, there are some legal claims which you might be able to make if this has not been done properly or fairly. It's really important to remember that the time limits for lodging a claim can be very short. In some cases, you have as little as 21 days after your dismissal to file a claim. In addition to the things we will discuss in this video, there are some other ways to find out your legal options. You can use the info guide tool on our website at www.elcwa.org.au to answer some questions and get the information which is most likely to apply to your situation. Or you can browse the information section of our website and read our fact sheets and information kits at your own pace. You can also call our advice line to see if you're eligible for our legal advice. Full details of our advice line can be found on our website and at the end of this video. In this video, we will look at 4 common issues that can come up when you stop working. Firstly, the amount of notice you're entitled to when you are dismissed. Secondly, other entitlements that you can usually expect to be paid out when you stop working, such as outstanding wages and accrued leave. Thirdly, redundancy. How much redundancy pay you might be entitled to receive and what you can do if you believe that your role hasn't actually been made redundant. And finally, what you can do if you feel that you have been fired without good reason. If your employer decides to end your employment, they usually have to give you notice that they are going to do this. The minimum amount of notice which your employer should give you is set out in the minimum conditions laws. It usually depends on your length of service. So, for example, if you're a permanent employee, your employer should give you 1 week of notice during your first year of employment, 2 weeks of notice where you have worked between 1 and 3 years, 3 weeks of notice where you have worked between 3 and 5 years, and 4 weeks of notice where you have worked for more than 5 years. Keep in mind that this is the minimum amount of notice you should receive. You may be entitled to more depending on other factors such as your age and any more generous notice periods under an award or industrial agreement or your contract of employment. There are also situations where your employer may not have to give you notice. For example, if you're a casual employee, your employer does not have to give you any notice. Sometimes your employer can also dismiss you on the spot if they pay you money instead of giving you notice. For example, if you are entitled to be given 1 week's notice, your employer can sometimes offer to pay you the equivalent of 1 week's wage instead of allowing you to work out the week. Finally, if you have engaged in serious misconduct, your employer may not have to give you any notice when dismissing you. There are other situations where your employer may not have to give you any notice. To find out more, you can read the fact sheet on our website called Minimum Conditions at Work. You can also telephone a government information line to find out specific information about your employment situation. If you're a national system employee, you can call the Fair Work info line on 131394. Or if you're a state system employee, you can call Wage Line on 1300 655 266. If you think you should have been given more notice because of an industrial award or agreement or because of your employment contract, you may wish to seek legal advice. There are a number of entitlements that your employer may have to pay you if you are dismissed. Firstly, you should be paid for all the work you have performed, even if you are dismissed in the middle of a pay cycle and even if you are dismissed for serious misconduct. It is generally against the law for your employer to withhold your wages from you, even if they are saying that you owe them something. If you're a permanent employee and are not employed on a casual basis, you may also be entitled to some unpaid leave entitlements. There are lots of rules around leave entitlements, but most employees are entitled to be paid out for annual leave which they haven't yet taken. You may also be entitled to long service leave where you have worked continuously for your employer for 7 years or more. For more information on long service leave, you can read the fact sheet on our website called Long Service Leave. You may lose your job because your employer tells you that your job or your position has been made redundant. A position is made redundant when the employer no longer requires anyone to perform the job. If your position has been made redundant, you may be entitled to redundancy pay. Not everyone is entitled to redundancy pay. You must meet certain eligibility criteria first. For example, under minimum conditions, you need to have worked with the employer for at least 1 year, and your employer must have 15 or more employees. For more information about these criteria, have a look at the fact sheet on our website called Redundancy. If you are entitled to redundancy pay, the amount you should receive usually depends on how long you have been continuously working for your employer. For most employees, this table shows how much redundancy pay you would be entitled to. As you can see, you could be entitled to between 4 and 16 weeks of pay depending on your length of service. You may also be entitled to more depending on your award, industrial agreement, or contract of employment. Sometimes, however, you may not believe that your role has genuinely been made redundant. You might think that your employer is simply saying this to you so that they can fire you and employ somebody else to do your job. It can be complicated trying to work out whether your position has genuinely been made redundant. To assist you with this, we have more information in the redundancy fact sheet on our website. If your job hasn't actually been made redundant, then you may have been unfairly dismissed and you may be able to make a claim against your employer. We'll talk more about what you can do about this in the next section. Losing your job can be a difficult and upsetting experience. Trying to work out what your legal options are might be the last thing you feel like doing, but it is important to know what your rights are because there are strict time limits for when you must file a claim. Sometimes these can be as short as 21 days from the date you were dismissed, so it's worth knowing what your options are early on, even if you later decide not to take any legal action. There are a few different types of claims that you might be able to make. We talk about the two most common types of claims. The first type of claim is called an unfair dismissal claim, and as the name suggests, it applies to a variety of situations where a dismissal is considered unfair. Both national and state system employees can make unfair dismissal claims, although the processes are a bit different. The second type of claim applies to a particular type of circumstance, and that is where you were dismissed for a reason which is not allowed by law. For state system employees, this second type of claim is called unlawful termination. For national system employees, it is called a general protections claim. A general protections claim is sometimes also referred to as an adverse action claim. You might think of it this way. Unfair dismissal claims are made when your employer didn't have a good reason for dismissing you or didn't follow a fair process when dismissing you. Unlawful termination and general protections claims are made when the reason for your dismissal is so unacceptable that the dismissal is considered more than just unfair. There is a list of these unacceptable reasons, and we call them prohibited reasons. One important thing to remember is that you must choose between these claims. You can't file more than one of these claims at the same time. But before we look at each of these types of claims, there is one thing we need to discuss. It's called constructive dismissal. If you want to make one of the claims that we have mentioned, the first thing you have to be able to do is show that it was your employer who ended your employment. In general, this means that you cannot file a claim if you choose to resign. Sometimes, however, employees resign because they feel that they were forced to do so by their employer's conduct. In other words, they feel that they had no other choice but to resign because the employer made their working conditions unbearable or because the employer gave them an ultimatum. In these situations, the employee who resigned might be able to argue that they were constructively dismissed. Constructive dismissal is not a legal claim. It's an argument that you may need to make as part of one of the claims we have discussed to demonstrate that it was your employer and not you that was responsible for your employment ending. Constructive dismissal is not an easy argument to prove, and each case will be different depending on the individual facts and circumstances. For more information, you can read the fact sheet on our website called Constructive Dismissal When You're Forced to Resign. If you have resigned but think that you might have been constructively dismissed, or you are thinking about resigning, you may wish to seek legal advice before taking any action. You can call our telephone advice line or contact a lawyer. If you have been unfairly dismissed, you might be able to make a claim against your employer. Your dismissal might have been unfair because your employer didn't give you a reason or any good reason for dismissing you, didn't give you any warning prior to dismissing you, or gave you a warning but didn't give you enough time to improve your behaviour or performance before dismissing you. These are just some examples of how or why a dismissal might be unfair. There are many other reasons why a dismissal could be unfair, and every situation will be different. Whether a dismissal is unfair will very much depend on the individual circumstances. You should also keep in mind that not everyone can make an unfair dismissal claim. For example, if you are a national system employee, you cannot make an unfair dismissal claim unless you have worked for your employer for at least 6 months. If your employer is a small business, you must have worked there for at least 12 months before you can make a claim. Other things such as your income and the regularity of your hours can also affect whether you can make a claim. For more information and more examples on unfair dismissal, you should read the fact sheets on our website. We have 2 fact sheets on unfair dismissal, one for national system employees and one for state system employees. An important thing to remember about the difference between national and state system employees is the time limit for filing an unfair dismissal claim. If you are a national system employee, you only have 21 days to make a claim. If you're a state system employee, you only have 28 days to make a claim. So if you think you have been unfairly dismissed, you should look into the issue as quickly as possible. You can sometimes make a claim outside of the time limits. However, it is very difficult to get a late claim accepted, and you must have a good reason why you couldn't make the claim within time. We have a fact sheet for this issue on our website called I've missed the deadline for filing a claim. What can I do? If you're a state system employee and your employer dismisses you for a prohibited reason, you might be able to file a claim for unlawful termination. Prohibited reasons are reasons that are not allowed by law. For example, your employer cannot terminate your employment because of your membership or non-membership of a trade union, because you have been temporarily absent from work due to illness or injury, because you filed a complaint about your employer to a workplace authority, because you took parental leave, or because of discriminatory reasons such as your race, sex, sexual preference, age, physical or mental disability, marital status, religious or political convictions, family responsibilities or carers' responsibilities. There are other reasons which are not allowed, and there are some rules and exceptions around the prohibited reasons we have listed. For more information, or if you think that you may have a claim for unlawful termination, please read the fact sheet on our website called Unlawful Termination for State System Employees. It is also very important to remember that unlawful termination claims must be made within 21 days of the date your dismissal took effect, which is normally your last day of work. If you are a national system employee and your employer dismisses you for a reason which is not allowed by law, you may be able to file a general protections claim, which is sometimes also called an adverse action claim. A general protections claim is wider than an unlawful termination claim. So national system employees can bring a general protections claim for any of the prohibited reasons we discussed in relation to unlawful termination, as well as a number of other prohibited reasons. For example, a national system employee can make a general protections claim if they were dismissed for exercising a workplace right. A workplace right includes any right an employee has under a workplace law. It also includes making a complaint directly to an employer and not just to a workplace authority. There are many different types of workplace rights, and there are a number of other prohibited reasons that apply to national system employees. For more information on general protections claims, please see the fact sheet on our website called General Protections for National System Employees. It's very important to remember that general protections claims must be made within 21 days of the date your dismissal took effect, which is normally your last day of work. If you're still not sure about the difference between unfair dismissal and unlawful termination or general protections, here are some examples to make it a bit clearer.
Come in. Hi, James. Look, we've had a look at your timesheets and we won't be needing you to work for us anymore.
What? How come?
Look, according to this morning's timesheets, you arrived 3 minutes late.
What? I'm sorry I was caught in traffic, but I'm never normally late, I swear.
That's true, but 3 minutes is 3 minutes and we have to let you go.
When I came in this morning, Mike was 20 minutes late.
Look, what Mike did or didn't do is none of your concern. This is about you, okay? So you're going to have to pack your things and go.
This is an example of a possible unfair dismissal. James might be able to argue that his dismissal was unfair for the following reasons. James was not given a valid warning prior to being dismissed. His mistake doesn't seem particularly serious. He was only late by 3 minutes. It seems that other employees have arrived later and were not dismissed. There have been no prior incidents of James arriving to work late, and his employer doesn't seem to have followed a fair process in dismissing him. Let's now take a look at a dismissal for a prohibited reason.
Come in. Hi, Julian. Thanks for coming in. Look, Julian, I'm very sorry, but we are going to have to let you go.
Really, why? I got a good performance review a couple of months ago.
Well, it's not really your work that's the issue. It's the complaint that you've lodged with WorkSafe. You should have handled this internally, and you did not. It appears that you don't trust us and you're not a team player, and that's very bad for staff morale.
There's bare wires near the water cooler. I told my shift supervisor last week, but nothing happened.
It's getting ridiculous. You're always complaining about something, and I've had it. I'm sorry, you're done.
In this example, it's clear that Julian was dismissed because he made a complaint to WorkSafe. This dismissal is against the law because it was for a prohibited reason, in this case, filing a complaint to a workplace authority. If Julian is in the state system, he can make an unlawful termination claim. If he is a national system employee, he can make a general protections claim. Julian might also be able to make an unfair dismissal claim in this second example. He might be able to argue that his dismissal was unfair because making a complaint about safety issues is not likely to be a valid reason for dismissing him, and because he hadn't received any previous warnings. A dismissal can be both unfair and unlawful, but you have to choose which type of claim you wish to make. You cannot make both. You should also note that each of these claims have different eligibility criteria and different procedures. They may also lead to different results. So before you do anything, you should have a look at the fact sheets on our website and consider getting legal advice from a lawyer or our advice line. As we said at the start, employment law can be complex and it can be difficult to work out which laws do and don't apply to you. Hopefully, after watching this video, it makes more sense and you are able to identify what issues you might have and who you can contact if you need further advice. To recap on that, if you have a question about your notice or leave entitlements, call the Fair Work info line if you're a national system employee on 131394 and call Wage Line if you're a state system employee on 1300 655 266. You can also use the info guide on our website to work out the fact sheets and information kits which are most likely to apply to your situation, or browse our information resources at your own pace. Finally, if you need legal advice about your specific employment law issue, you may wish to contact a lawyer, or you can call our telephone advice line to see if you are eligible for our legal advice services. Our advice line is open from 9 a.m. to 3:30 p.m. on weekdays except Wednesday. It is also open late from 5 p.m. to 7:30 p.m. on Tuesdays. The telephone number is 1300 130 956, or you can also call 9227 0111. If you're an employee in a regional, rural or remote location, our dedicated line is open from 9 a.m. to 1 p.m. on weekdays except Wednesday. The telephone number is 1300 520 054, or you can also call 9227 0185. We hope the information in this video has been useful for you. Thank you for watching and for your interest in the Employment Law Centre.